Good morning. We're all here today to try to resolve this litigation. Oh, wait, we're not all here today. Ms. Spears is not here. Oh, there she is. Well, she's got to put her headset.
Oh.
Welcome. Well,
sorry, folks.
Welcome, Ms. Spears. We were going to start without you.
Yeah, sorry about that. It's just that I got this part-time job reclaiming orphan wells because I'm just using it to supplement my income because I'm waiting till the courts are opened again or till my matters become urgent and emergent. But the benefit of it is I get one of these. So when they do call me to court, I actually have the PPE. So anyhow, let's move on.
Okay, well, today we're going to try to resolve the litigation arising out of a motor vehicle accident which occurred on July 19th, 2017. This is a mediation, voluntary, and everything that's said today is said without prejudice, meaning that it can't be used later in the litigation. Before we go on, though, I want to just talk about a few other. No one is to record this meeting. Not on your computer, not by phone or by any other means. Second, you might take written notes, but you can't use them for any purpose other than facilitating this meeting, so you might not bother taking long notes. Next, I will not be subpoenaed in the event that the matter moves forward. First, I won't do this if I'm going to be subpoenaed, but secondly, I wouldn't have any useful input to provide at trial because this is all without prejudice. Finally, there may be confidential meetings that we have in our breakout rooms or using the technology available on this teleconference. If you say something to me in confidence, I will not use it unless you authorize me to disclose that, and vice versa. Any conversations we have in our private meetings will remain confidential, except as I'm authorized to reveal it. I hear voices, Mr. SARS, from time to time. This is, of course, a confidential meeting, so from your house, and those are your children?
Yes, I apologize. As you can see, I am in my house, and I do have children who are playing in the backyard very loudly. But this is confidential, and
okay.
They are outside of the house.
Okay, well, let's get started. Let's introduce the parties. I understand, by the way, that liability is not an issue, but let's introduce the parties.
Well, thank you. I can do that. So, good morning, Mr. Harris. My name is Brittany Spears, QC, and I'm counsel for the plaintiff. It's Kelly Smith. My friend, Ms. Carey, is counsel for the defendant driver. And the other guy is the defense adjuster.
That is correct. My client today here is Mr. Bruno SARS, who you've spoken with. He's an insurance adjuster at Automatic, the leading insurance company in Alberta.
Good morning. Good morning, everyone.
Nice to meet you. Ms. Spears, I have reviewed your brief that you've provided, nice voluminous brief. And the letter that Ms. Smith has written, setting out how the accident has changed her life, that was very helpful. It's my understanding, Ms. Smith, that you don't want to speak today. Is that right?
Yes, that's correct. I think the letter sets everything out.
Okay, Ms. Spears, then, could you please provide a summary of your position?
Yes, thank you. So as you mentioned in your opening remarks, liability is not an issue. Counsel have generally agreed upon general damages, future and past cost of care, as well as past and future loss of housekeeping. The only real issue is past and future loss of income, as well as loss of capacity. So Ms. Smith was traveling westbound on 124th Street. She came to a complete stop at a red light on 104th Avenue when she was rear-ended by the defendant driver. She was immediately taken to the Royal Alex, and she was diagnosed with a concussion and a fractured tibia. She had surgery on that leg, and she was discharged 3 days later. She went to her family doctor. She was also diagnosed with WAD 3. So the minor injury regulation is of no relevance here, and continues to undergo physiotherapy treatment to this day. She can only be described as having perfect health before the accident. She was a rising social media star with thousands of followers, many businesses contacting her to pay her for sponsored content. She could easily make $10,000 for each post of sponsored content. Many of these posts showed her engaged in exciting activities while promoting athletic brands. Now that an entire stream of income has dissipated, as she can no longer engage in these activities. We have several expert reports indicating she will never be able to. As you'll note from the briefs, our assessment of loss of income, loss of capacity is $2 million. This is significantly higher than the defendant's assessment of $20,000. It is our position that our report and assessment should be preferred, given that our expert undertook significant research of similar influencers and their projected income. So it's our position Ms. Smith was on a similar trajectory and could have expected a similar income but for the accident.
Okay, Ms. Carey?
My comments will be brief. As you and Ms. Spears have noted, liability is not an issue. My client does not dispute that Ms. Smith suffered serious physical injuries in the motor vehicle accident. However, what is in dispute is the effect that those injuries and their sequelae had on her past and future loss of income claims, as well as her future loss of capacity claim. Our expert has assessed Ms. Smith's future loss of income and past loss of income claimed at about $20,000. While Ms. Smith had admirable hopes and aspirations of becoming a rising social media star, the facts in this case are that she simply was not on that trajectory. Ms. Smith's followers were mostly purchased, which means that they aren't real individuals. While Ms. Smith has provided evidence and direct messages and emails with some of these companies indicating that there were potentially contracts that were being negotiated, our evidence and the evidence she's provided indicates that no contracts were actually signed, and many of these companies have since gone out of business. Furthermore, Ms. Smith has failed to provide any T4s or any other documentation to support her proof for her loss of income claims, and without these documents, her claim is simply based off of pure speculation. Although she did live an exciting life, it's clear that she was not able to monetize that lifestyle in any sort of meaningful way prior to the accident, and the but-for test has not been established. We are asking that our expert assessment be preferred in this case because it is grounded in the documents that have been provided.
Okay, well, thank you. As we discussed before we got started, we are going to caucus now. Alexa, would you please take us to separate meeting rooms?
I will now place participants into their breakout rooms, Mr. Harris.
Well, I did not like what defense counsel had to say. I just thought that was so unfair. And how long do you think this is going to go on for?
Well, it depends. Any amount of time. I've been to some that have been a couple of hours, but I've also been to ones that last to 4:30. The main thing is that we stay until either we have a settlement, we're here in good faith, or until there's nothing more we can do, and then we leave. So let's just get comfortable. I can tell you that I've had a number of files with these, both the lawyer and the adjuster, and we've generally been able to resolve them. And if we have taken them to court, of course, I've always won, so I don't think they want that to happen. So.
Okay. Well, is it okay if I check my Instagram?
You go ahead.
Thank you.
All right, so you've heard their position. What do you have to say about that?
Yes. Are we waiting for Mr. Harris?
Oh, yes, of course. I think he's still being transferred over by Alexa.
Yes.
Okay, so we're now in our own meeting room.
So, Ms. Carey, to answer your question, certainly there is a ceiling that I'm authorized to agree to. Without going into specific details, I can tell you we are quite far from that. I think their number is, I would say, more than double what I'm authorized to agree to today.
Okay, well, and I can appreciate that. I think their assessment for loss of income is just simply too inflated. What I would recommend is that we go back with an offer of $445,000 all inclusive, and bearing in mind here, about $50,000 of that amount is going to be costs.
Okay, so it's an offer you're suggesting of really $395 plus $50,000 cost for a total $445 all in. Is that the offer you're instructing me to go back with?
That's what I would recommend. Mr. SARS?
I would agree to that. Yes.
Okay. Alexa, can you take us back to the main room?
Thank you.
Moving now, Mr. Harris.
Okay. Want the good news or the bad news?
Definitely the good news.
Okay, well, good news is we have an offer. The bad news, from my perspective, is that the offer is for $445,000, all inclusive.
But we were asking for 2.5 million.
I know, Kelly, but as we discussed, that's your absolutely best case scenario. It depends on you getting the best judge on the best day and everything going well. So while I think 445,000 is within the range of reasonable result, it is on the lower end. I don't think it adequately reflects the risk the defendant would risk or would have should this matter proceed to trial.
Okay, well, I agree that the defendant may have underestimated the risk, but I think you may have overestimated the strength of your case. Ms. Smith, you have to be aware of some other things. In addition to risk, first of all, you'll be vigorously cross-examined at trial. The case is about your lifestyle. That will involve cross-examinations on every aspect of your lifestyle, your marriage, everything. And as well, trial, as I'm sure you've discussed with your lawyer, is expensive, it's time-consuming, and particularly in light of the recent shutdown of the courts or the suspension of the court's activities in anything but emergent matters, your trial is not going to be for another maybe 3 or 4 years. So those are factors that you have to think about.
Okay, I mean, I can't put my family through another 3 to 4 years of this, and I don't want to be cross-examined. I mean, defense counsel is mean enough here. So I think, you know, I think I'd be comfortable going back at 1.5 million. I think that's fair. What do you think, Britt?
I think that's a fair amount.
Okay, so the adjuster may not have the authority to settle for that amount, but usually things don't resolve with the first volley or two of offers. So I think it's appropriate to go back with that. Perhaps we can, if we can't resolve it today, it might be resolved shortly after today's proceedings are over. So are those your instructions to go back at 1.5 million?
Yes, I can live with that. Thank you.
Ms. Spears?
That sounds good. Thank you so much for your work today.
Okay, Alexa, can you take us back to the main room with one present?
Moving now, Mr. Harris.
Thank you very much for your hard work today. We've been successful at resolving this. I'm pleased to confirm with everyone present that we have settled Ms. Smith's claim for $800,000 all in, and the defense will cover the cost of the mediation. They say that the best settlement is one where everyone is a little unhappy and reach that.
Oh my goodness! I have a matter. It's become urgent and emergent. I have to get to court. Thanks, everyone. See you.
Okay, well, as Ms. Spears knows from previous mediations, I will immediately send out some notes sketching out the terms of the settlement, and I will expect everyone, at least the two lawyers, to get back to me right away, confirming the terms of the settlement, and they can do the more proper paperwork later on to bring it to a conclusion. Thank you very much.
Thank you.
Thank you, Alexa.